Welcome to this latest Digital Policy Institute video webinar. Coming off a year of political gridlock in Washington, and now with a Democratic majority in the House of Representatives, many see 2019 as the year Congress will pass comprehensive privacy legislation, ideally with provisions that protect consumers, but also encourage continued investment in the technology sector. This past July, a DPI webinar took a first look at the privacy debate, but that was then. Today we'll revisit the debate and tackle some of the privacy issues that likely will come out of the 116th Congress, as evidenced by recent congressional hearings. Will the Federal Trade Commission be the cop on the beat? Will states be acting faster than the federal government in passing legislation? And how can a more consistent framework be achieved across the entire digital ecosystem? Hi, I'm Barry Umansky. I'm Senior Policy Counsel and Senior Fellow at the Digital Policy Institute. Created back in 2004, our institute produces research and policy papers, conferences, and webinars that have covered a wide range of legal, economic, and policy-related issues. To learn more about DPI, go to digitalpolicyinstitute.org. The matters we're talking about today are complicated and controversial, but we have an outstanding panel to explain the issues and arguments and predict the likely future for privacy-related decisions under the new order in Washington. I'm in the DPI studios in Indiana. Our three panelists will join us shortly. You'll find their full bios on the DPI website. Brett Swanson is a visiting fellow at the American Enterprise Institute and president of Entropy Economics. His research and policy focus is on the impact of technology on the U.S. economy, telecommunications, and internet regulation. He began his career as an aide to former Senator Richard Lugar and served as an economic analyst to former House member and Secretary of Housing Jack Kemp when both were at the free market advocacy group Empower America. He later advised technology investors as the executive editor of the Gilder Technology Report and directed the Center for Global Innovation at the Progress and Freedom Foundation. A frequent contributor to Forbes, the Hill newspaper, and many other national publications, Brett will join us from Indianapolis. From Washington, D.C., we have Jennifer Huddleston. Jennifer is a research fellow with the Mercatus Center at George Mason University in Arlington, Virginia. Her research focuses on the intersection of emerging technology and law. Jennifer's work covers judicial deference, liability protection for internet platforms, autonomous vehicles, the benefits of technology and innovation, and of course, the regulation of data privacy. Media outlets discussing her work include USA Today and the Chicago Tribune, the Washington Times, and U.S. News and World Report. Also in Washington is Patrick Halley, Senior Vice President of Advocacy and Regulatory Affairs at U.S. Telecom. He leads U.S. Telecom's policy development and advocacy efforts before the White House and the executive branch, regulatory agencies, courts, and other government operations. Prior to joining U.S. Telecom, Patrick was a partner at the Washington firm of Wilkinson Barker Knauer, where he advised communications providers and trade associations on strategic, policy, and legal matters. He previously was the FCC, holding several senior positions there, including Associate Chief of the Wireline Competition Bureau, Acting Director of the Commission's Office of Legislative Affairs, and he also was a legal advisor to two Wireline Competition Bureau chiefs and an FCC chairperson. Again, full biographies of today's panelists are found on the DPI website. So let's get to work. And let's start first. I'd like to ask Patrick Halley, before we dive into the weeds and the details of privacy regulation, what are some of the overarching principles that you think should be governing on Capitol Hill, in the states, and elsewhere, the regulation in these areas of privacy? Patrick.
Thank you, and thank you for putting this event on. That's a very important topic. It's certainly one that's getting a ton of attention here in Washington right now and in the states, and I think that's because there's a recognition that the data that is used to provide the services that many of us depend on a daily basis, that there's a lot of it, and consumers care a lot about what data is collected, how it's used, and want to have a sense of empowerment and a little bit of control over how that information is collected and used. And so it's a really important issue. At the same time, consumers want to continue to benefit from the innovation and the services that are made possible by the data that drives the internet economy. And so I think you hit it right on the head when you talked earlier about the need for, real consumer protections that make folks comfortable and want to get online and want to provide information to make the internet engine run. But at the same time, we respect that consumer privacy and the consumer needs in a way that's not overly restrictive, that sort of inhibits innovation and investment, as you talked about earlier. So in terms of some of the principles, in terms of from U.S. Telecom's perspective, what that looks like, there's a couple key points for us. First, the need for a national framework. I think we have, very serious concerns about, a 50 state-by-state approach and the balkanization of the internet. That's also true when it comes to net neutrality, for that matter. Second, we think that the FTC is the expert agency on privacy, not just for the internet, but for other types of services. And we think that there should be a single federal agency that's responsible for the oversight of privacy. And we think the FTC is the right agency. And also for us, it's really important that we look at this from a technology neutral standpoint, right? That we don't have separate rules and separate agencies administering privacy regulation. That's one way because it happens to be an internet service provider, and another way because it happens to be an edge provider, if you will. So national framework, technological neutrality, single federal agency, these are important. And then in terms of, what some of the specific issues, and I'm sure we'll get into this, of course, there are core principles around issues like transparency and making sure that folks understand, what the data is, how it's being collected, and how it's being used, and that there's a respect for consumer choices. But that has to take the context of what the data is and how it's being used into consideration. And we continue to think that the way the FTC has been doing this for many years now, which is a sensitivity-based approach, is important. And so those are some of the key, key principles that we think about as we move forward.
A good description of the waterfront. Thank you, Patrick. Staying in Washington with Jennifer Huddleston. California, most notably, has been active in the area. And the prospect of having state-by-state patchwork of different regulation, I think is of concern to all. From your perspective, Jennifer, what are those pluses and minuses of federal preemptive legislation as opposed to a patchwork of state regulation? Jennifer Huddleston.
Well, last year we saw California pass the California Consumer Protection Act, or the CCPA, which would bring about sweeping changes to data privacy in early 2020 if there isn't federal preemption or some other sort of action prior to that law going into effect. Other states have seen this, and in this current legislative session have introduced various bills to also have state-level data privacy laws. And it's a wide range of states. We've seen states like North Dakota, as well as larger states and even some cities like the city of Chicago try and take this issue up on their own. The internet, by its very nature, is borderless. And I think a lot of us have really benefited from the fact that it allows communication and innovation to travel across state lines, across city lines, and across internationally with minimal barriers in between. Every time states pass their own data privacy laws, that introduces another border that new innovators will have to comply with or choose not to act in those states. As a result, on a state-by-state case, you could certainly see either this 50-state patchwork where no one's quite sure what to do, or you could see a case where one single state becomes a de facto national regulator and the rest of the citizens haven't really had a voice in that decision.
Jennifer, thank you. I want to go to Brett Swanson in Indiana. Brett, you've done lots of work in the area of the impact of privacy and privacy regulation on industry, particularly healthcare and transportation. Brett Swanson, tell me about the points that you've underscored in your research in these areas. Brett Swanson.
Yeah, thanks again for having me. A lot of my work the last couple of years has been focused on how technology impacts different industries. We've had this amazing explosion of data and information and the internet and mobile over the last several decades, but it's mostly sort of revolutionized things like entertainment and media and finance and other industries like healthcare, transportation, manufacturing. in my view, have not fully exploited this amazing power of information, internet, data, mobile, coming, artificial intelligence. And so you see it in the productivity data, where the digital industries, which make up about 30% of the economy, demonstrate, very strong innovation, very strong productivity growth, and therefore strong income growth, and all the other good things that comes along with that. The real problem, the productivity slowdown over the last dozen years has really been concentrated in what I call the physical industries. So that's, healthcare, manufacturing, transportation, retail, logistics, etc. And the upside of that underperformance, you could say, is that there is a huge opportunity for 70% of the economy to leverage the information tools that they have not yet in a full way. And so I look at something like healthcare, where we've seen flat productivity growth for the last several decades, where this is a fifth of our economy that just isn't innovating like we would like it to. But it's obviously super important, both because of its size and because it's about our health, something we care very much about. And so I think one of the biggest opportunities for data is in an industry like healthcare. So this means personal health. It means using our smartphones and wearable devices to collect data. It means communicating better with our physicians and delivery mechanisms. It means smarter insurance products. It means collecting the genomic data, doing all sorts of research with genetic data and all the other omics, as we like to call them. And at the same time, health data is among the most sensitive that we know of. And so we've got to find this balance, and maybe we can do this through a new law and through new norms and technologies and institutions, to find this balance between taking advantage of the amazing opportunities that data offers us, and at the same time protecting this very sensitive data. So that's sort of, in a nutshell, the way I look at how this privacy law can actually have a big impact, if we get it right or not, on the economy.
Thank you, Brett. I want to take more of a global look for a moment, and we'll get back into some of the details. Jennifer Huddleston, the European Union has enacted the General Data Protection Regulation. What if the United States does nothing in light of the GDPR? What would the outcome be? Jennifer Huddleston.
I think that's a good question, and I think that is driving a lot of the conversation around data privacy. Is we've now had the GDPR in action for almost a year, and there are some people that are kind of asking that question of, well, why don't we have those same protections? But what we've also seen out of GDPR are a lot of potential negative impacts. Not only has it established a regulatory scheme that requires often millions of dollars in compliance costs, it also can kind of create this false sense of security, in the sense of you're so tired of clicking through those emails that a lot of people got last spring, or clicking yes, I accept cookies, that you are paying even less attention in some cases than you were before. It also has prevented people in Europe from accessing certain resources that many people would like to, be it a medium or large scale thing like newspapers. The LA Times is still not available in Europe, nor is the Chicago Tribune, last I checked. We've also seen smaller players had to exit the market. So for those that are concerned about really encouraging that next generation of innovation and helping new products get off the ground, it's had a negative impact, because often they have to choose between the cost of compliance or investing in innovation. Particularly in the ad sector, that's actually resulted in the larger players, people like Google and Facebook, actually gaining market share. So right now, the US still has this wonderful, rather permissionless system that allows anyone with a good idea to at least start testing it out and try and come up with a better alternative that may actually provide a much better privacy option than what we see in the market right now.
Jennifer, thank you. Patrick Halley, you know, oftentimes the issues of privacy and net neutrality are commingled in the big debate. Now, in light of the fact that in the House there is legislation being introduced to restore some kind of net neutrality, what's your thought about whether these issues should be addressed separately or be intertwined through the legislative process? Patrick Halley.
Well, we could talk for the next hour just about that if you want, but let's not. So, I mean, a couple points there. As a general matter, I feel pretty bullish that we can actually make progress at the federal level on privacy this year. I think that the leadership in the Congress, many of the members who are going to drive that discussion actually want to get something done. You know, call me naive, but I think there actually is some desire on the part of many important leaders in the Senate and the House that think this is an issue that really does affect everybody, and there, because of the GDPR and because of laws like California, that there really is a need for congressional action. So I think that there's a good chance that something actually could get done, and we can talk a little bit more about how and why that is. I think net neutrality has become so polarizing and unnecessarily political that to try to marry these two issues, I think, is really difficult. Look, in a perfect world, for some of the same exact reasons that we think we should have a national privacy law, we think there's absolutely room for national level activity on net neutrality, so we don't have the same sort of 50-state issues and we don't have this back and forth and regulatory ping pong. I would love to see it get done at the national level. We're very supportive of net neutrality rules adopted at the national level. But I'm concerned that the progress that I really do think is possible on privacy might get bogged down if we sort of try to combine the issues. But there are some overlapping issues there, right? There's the states feeling this sort of perceived need to fill a regulatory void that they sense because of a lack of action coming out of Washington. That's sort of both net neutrality and privacy sort of are in that same bucket right now. And there are other issues too about, you know, which agency should have responsibility, how much regulatory authority and rulemaking authority should that agency have, should it be boundless, how can we put guardrails on any rulemaking authority that may be provided to the FTC, for example. So there's some overlapping issues, but from just a sort of pure politics answer, I think that the likelihood of the two being done together is low, and that's probably good. If you're going to get a national privacy bill done.
I want to ask Jennifer, you know, one of my favorite amendments to the Constitution is the First Amendment. And one of the overarching questions right now is, what about free speech when you're also looking at privacy? Where are the trade-offs? Jennifer Huddleston.
Whenever we're considering privacy legislation, that's certainly something that needs to be carefully considered. When you look at some of these more expansive definitions of privacy and more expansive definitions of privacy harm, particularly with things around, say, a right to be forgotten, inevitably you're going to have tensions between one person's right to privacy and another person's right to speech. So take, for example, if I were to post a picture of you on Facebook right now, and you have a right to privacy and you asked for that to be taken down for some reason, that's your right to privacy, but at the same time, my posting the picture would be my right to speech. In some cases, we find that the individual's right to speech needs to be protected more than some rights to privacy. In other cases, we say there's some information that's so deeply personal and that the speech about could be so harmful that the privacy right needs to supersede. So we just need to be careful when we're having these conversations that we're aware that these two rights often intersect and that we're making sure that the tension doesn't get out of balance, because we have in America valued our First Amendment rights to speech so highly.
Which, just to add to that, sort of, you asked about the GDPR earlier, that sort of American free speech right is not necessarily the same sort of sets of values and rights that somebody in Germany might necessarily think about, just as one example. And so in terms of sort of porting the GDPR to America, there's many concepts of GDPR that are not foreign to the United States and that sort of overlap some of the things that are in the California legislation, and I think we'll probably see in proposed federal legislation. But there are other pieces of the GDPR or sort of the context behind it that are driven by a different just history and a different set of expectations and rights that the U.S. has compared to other parts of the world. And I think that context is relevant as we think about how to proceed.
Thanks, Patrick. By the way, there are also free speech rights in Indiana where we have Brett Swanson. Brett, I'm going to throw it to you for your commentary on what you've heard the last few minutes and what else you'd like to add to our discussion today. Brett Swanson.
Yeah, thanks. Just to add to what my two colleagues just said, which was very smart about free speech, I think this gets to a point about why I think, and a lot of others think, that the Federal Trade Commission is probably the best suited agency to take up these issues, and why we should probably bolster its authority, which it's already been exercising in the digital privacy area for the last couple decades. And that is because of the way it analyzes these issues with a focus on consumer welfare, using an analytical framework that tries to balance costs and benefits of these things. And because privacy is sort of an inherently slippery topic, I think that's why we need this approach. You can imagine if we tried to write in a law and in specific regulations, tried to imagine every single different type of situation, every single different type of data, every single type of transaction in the future, and tried to write detailed prescriptions and proscriptions, that we wouldn't be able to address all the situations that will come up in the future. Partly because we do have these offsetting values between privacy, speech, et cetera. Also, just because of innovation and the heterogeneity of data types and prices. So my view is that the FTC, which does have this more generalized framework that tries to figure out whether there's been an actual consumer harm and tries to quantify it, even though in some cases that might be difficult, is probably the best way to go to analyze these situations, which we can't imagine every scenario today.
Thanks, Brett. Back to Washington and Jennifer Huddleston. We've talked about legislation from states, legislation from the federal government. What other tools of the trade do we have there to address what Brett rightfully mentioned is the greatest concern about consumers' expectations of privacy? Jennifer Huddleston, what are some of the other things that might be in our bag of tricks to satisfy these concerns about privacy?
As Brett just mentioned, the FTC has been addressing these issues on a case-by-case basis for some time. As a result, they've developed various tools such as consent decrees and other administrative actions to address harms when they occur. We do have some existing federal legislation that will address these in some of the most sensitive areas too. So for example, COPPA already addresses children's online privacy. HIPAA addresses some of the healthcare concerns. Various financial regulations address that most sensitive information. And while some of those laws may need updating, they do exist to address those areas that have already been identified as having various very serious opportunities for true harm. Another interesting area to consider is what role soft law from administrative agencies could play in this area. So soft law refers to those various tactics that an agency may use that aren't formal rulemaking or don't require formal legislation. A lot of times people tend to view these negatively, but particularly for new and emerging technologies, these can provide kind of a system of information that allows innovators to know they aren't going to get slapped down by the regulatory agency, but still provides some sort of check for consumers and policymakers on what's going on in the technology. So we've seen a lot of this with the way NHTSA has addressed driverless cars with their guidance, but we've also seen it in other areas too, be it a regulatory sandbox or some sort of multi-stakeholder task force that allows innovators, civil society, and regulators to come together and discuss the issues and come up with a solution that can kind of properly balance the interests of all those different players.
Yeah, understand. Earlier today, Patrick, when you were giving your overview of the issues. You talked about the need for any regulatory approach to apply just as much to edge providers as ISPs. I'd like to delve a little more deeply into that issue. Why is that kind of uniformity best, Patrick?
Well, I think it's from the consumer's perspective, I think it's seriously confusing to have a set of rules that only applies to, let's say, Comcast or Verizon or AT&T or some small rural broadband provider, but not have those same rules apply to the search engine or the social media platform. And when you say that we have, we've enacted privacy laws, for example, and they only apply to sort of one part of the consumer's internet experience, I think that is a recipe for confusion on the consumer's part. I also just don't think it makes sense just from a technology standpoint. Look, the way in which a broadband network works and the way in which a search engine or a social media platform work are not identical. But in terms of rules, it makes a lot more sense to have rules about data privacy, about the information that's collected and how it's collected and how it's used, rather than who's collecting it, right? Because really it doesn't matter. Data is data. And so it just makes a lot more sense to have a set of rules that apply across the board. Look, some people think we should have, we're only talking about the internet right now. Some people want to make sure that when we have a national privacy law, it deals with literally every form of information, right? And not online, but sort of retail data collection and information as well. We're talking about sort of online activity right now, but as a general matter, we think it's appropriate for there to be sort of one set of rules that governs data, regardless of who it is that's doing the collection and who's using the data. And so that, and look, we had an experience a few years ago where the FCC decided that they needed to become the privacy cop on the beat, but only for internet service providers. And the FCC adopted very strict rules that literally only applied to the ISP. And look, many companies are now integrated, offering multiple different types of services, from content and online services to network connectivity, right? So you can imagine a world in which a single company is subject to very strict privacy and data collection rules for its provision of broadband internet access service, and has a completely, with the FCC as the regulatory authority over that business unit, whereas, their use of data from their content side of their business was governed by the FTC with a completely different regulatory regime. That just doesn't make sense. It doesn't make sense in terms of just good government, good policy, but it certainly doesn't make sense for the consumer, who really has no idea what their data is being subject to, depending on which company it is. And so we just feel it's important that there be sort of a regulatory level playing field on that issue.
Yeah. Earlier today, Brett mentioned the impact of privacy regulation on large sectors such as healthcare and transportation. But Jennifer Huddleston, staying back in Washington, Jennifer, what about the regulatory burden that's being felt on small business? They have some great concerns. Could you perhaps articulate what some of those concerns are for small business?
Absolutely. A lot of regulatory burdens regarding privacy have a lot of compliance costs associated with them. They require quick responses. They require different data retention policies. Of course, it varies from policy to policy what exactly those responses will be. But when a company's new and it's 5 people in a garage trying to develop the next great internet giant, having to add a 6th person that's an attorney to deal with the data privacy issue is going to add significant costs that in some cases companies can't afford. Therefore, a lot of companies may face the choice of either investing in those compliance costs rather than their product, shutting down, or limiting certain users from certain markets, which then can cause problems with getting off the ground. But not only can this impact, your internet startups, it can impact even things like retail, as was just mentioned. A lot of stores now are going online, so even your mom and pop shop down the street could be impacted by certain data privacy policies if they have an online component as well.
Got it. We've covered a lot of territory so far. What I want to do is go back to Indianapolis and Brett Swanson. And Brett, I'd like to give you an opportunity to give your predictions for the rest of 2019 and maybe creeping into 2020. What are your expectations in terms of the legislative and regulatory front when it comes to privacy, Brett Swanson.
Yeah, it's interesting. I think this topic, digital privacy legislation, has more momentum, more bipartisan momentum than you know than any issue we've seen in a while. Certainly in the technology space, where things have been rather contentious over the last decade. So that's really encouraging. I think that we've got some people that actually want to solve some problems. Hopefully, we can do it in a balanced way. So far, it seems to be moving along slowly. So I guess you'd have to say, from a substantive point of view, things are going well. You always have to think about also, though, that the political environment that we're in right now, from a higher level viewpoint, is not exactly maybe not the best, is very polarized. And so from that point of view, you might say it's going to be difficult to get anything done this year. But they did criminal sentencing reform. They got that through. They've done some other things. And so maybe this is one of those issues where we can put aside the sort of the extreme polarization for a little while and get things done. If any issue can do it, I think this may be one.
Thanks, Brett. So hope for getting things done. Back to Washington. Patrick, what do you think?
Yeah, so I think that, as I mentioned earlier, I agree. I actually think there's a good chance that we could get legislation done. I hope this year, if not this year, by the end of the Congress. Although for me, the closer we get to election, the harder it is to do anything, just as a matter of course. But we're at a period now where we've had a lot of conversation. There were multiple hearings there were a hearing in the House and Senate last week on this topic. There's going to be a hearing in the Judiciary Committee soon on this topic. There will be more hearings in the Senate and House Commerce Committees over the next few weeks and months. There is active bipartisan negotiation amongst multiple senators who are leaders on the Senate Commerce Committee. We hope to see a draft bill emerge from that process soon, maybe by the end of this month. Maybe I'm being optimistic. But it has, serious people having serious conversations, certainly being informed by many folks who have gone in to see them with their views. You also have, I think, a recognition by industry, the tech industry, the communications industry, that the status quo right now, where you have a European law that affects American companies, a California law that, as was mentioned earlier, could become the status quo if there's not, because of the sort of just the natural impact on a law that comes out of a state like California sometimes, that there really is a need for federal legislation. It's not just a nice to have, it's really a must have. And look, California, we may quibble with certain parts of it, and maybe some parts are okay and some are a little more onerous, but it's not the only law. Washington State having a very active discussion on that. You mentioned other states as well. And even if they all said the exact same thing, right? This is one thing that I hear about all the time. Well, why do you care if states are active if you're able to comply with the actual law? First of all, there's an impact in terms of a regulatory compliance cost on any state that does it. But even if they said the exact same thing, California gives a lot of authority to the Attorney General to interpret all the language in that very long piece of legislation. Other states will have, whether it's the AG or some other agency that they identify, they will have different interpretations of the same concept. And that's crazy. For the internet, there's no California internet, there's no Maryland or DC internet, there's no US internet. So the idea that we're going to have different companies, many of whom operate in multiple states, if not all the states, who have business and contractual agreements with app providers and social media platforms and search engines and others and cloud service providers who have sort of national level contractual agreements, and they're trying to figure out how to comply with every one of these states. That's not good. It's not good for consumers. It's not good for innovation or investment. So I think people just really recognize that. That's why I think maybe we really actually can get something done. Now, there's a whole lot of debate and details around get something done that are going to be required. And I think people from my industry and the tech industry that will now be supportive of giving the FTC rulemaking authority, if it's sufficiently narrow and cabined and not just the sort of broad rulemaking authority to do whatever they want in this space, I don't think that was the case 2 years ago, maybe not even a year ago. But I think there's a recognition that there has to be some compromise on both sides, and that there's a benefit, real significant benefit to doing it at the national level. So I think that's why I'm optimistic.
Jennifer, same with you.
I think I think one of the good things that has come out of this whole conversation is hopefully some consumer education and also some innovators paying attention and coming up with new products to solve these problems so that we would be less reliant on regulation or legislation to step in. I think a lot of us really became aware of what our options are and have done things like check our Facebook privacy settings or figure out, whether or not they really want to accept the cookies and not just clearing them because you want to see what it does to your flight prices. So I think that that's really been a good step. And I also think that, watching what happens next will be interesting, not only in terms of the debate, but also in making sure that nothing is rushed so much out of a sense of urgency that we make trade-offs that we may later regret. So certainly this is a very important conversation to be having, but it's also a conversation that could have a great impact on a wide number of industries as more and more data is being used across the board, as we heard from Brett earlier.
And I would actually love to get Brett's take on this too, which is every consumer sort of, not every consumer, consumers sort of say conflicting things at times, right? They really value their privacy. They really want to know how their data is being used and that it's being protected and it's not being used for things that they don't know about. And that makes sense. At the same time, consumers really love free services. Consumers really love the way in which the internet economy so far has worked. I mean, it's great to be Facebook and Google when you never have to send a bill to your customer. You know what I mean? And that's been a model that's been extremely effective. And so what sometimes gets lost in the debate about the use of personal data is that it really enables a ton of really important, useful services that we depend on every day. And so, I don't want that to get lost in the discussion at all, because that's important.
Okay, Brett Swanson, comment on Patrick's statement just then. What are your views?
I'll just reinforce Patrick and Jennifer's very good points in a number of different ways. So, the last year, U.S. internet traffic reached something like 50 exabytes per month. And, global data global data center traffic this year will reach something like 14 zettabytes worldwide. And so customers are voting with their feet. They're saying that we get a lot more benefit out of these data flows than costs, right? So not to say there aren't costs, but overall the data economy has been a huge boon for us, and as we extend it to other parts of the economy, can really help as well. And I want to take off something that Jennifer mentioned, is that as we think about legislation and new rules and new authorities for the FTC, which may be appropriate in some cases to give consumers and businesses confidence and insight into the way we're going to govern these things, we also have to make sure that we don't erect too many obstacles to this innovation. And that's why I think that a new law should be a foundation, right, for the other things that will improve our ability to manage this privacy topic, which is a lot of times hard to define. So that's why I think things like civic institutions, whether that's things like privacy ratings or seals of approval or consumer reports or things like that help consumers make decisions, right, but that aren't government-based, and also just sort of civic norms. We're going to have a lot of this is going to have to be on a person-to-person civic basis, right, where we figure out these things as we go along. What types of behaviors are allowable? Which types of behaviors are frowned upon? And then the other thing is that will be super important that Jennifer mentioned is technologies themselves. So we'll develop new technologies to solve the problems that other technologies are creating. So whether that's anonymization of data, whether that is crypto assets and blockchains that may have some applicability here, to secure identities and transactions, all sorts of other technologies that will help us solve these problems. And what I really hope is that any law that we have acts as just a foundation, but that most of the work gets done through new institutions and norms and technologies.
Brett, thanks for those thoughts and from the wrap up from Indianapolis. Back to Washington, same thing. What else would you like to discuss for the good of the order before we wrap up this webinar? Let's start first with Jennifer Huddleston.
I think it's important to remember in all of these conversations that we've had privacy panics, so to speak, before. While we're particularly discussing data privacy, our initial privacy panic, so to speak, goes back to the turn of the 20th century with photography. People were convinced that this would, ruin everything. Nothing would be private anymore. All of our information would be available. And yet here we are now, and I don't think anyone today is super worried about the presence of just a basic snapshot of them. At the same time, we've seen it with things like caller ID of was this going to allow doctors to be able to take calls at home. So these conversations have happened before, and in general, between changing social norms, working with innovators, and in some cases, some minor regulations or minor actions through the courts, we've been able to balance it and come at a solution that tends to work pretty well for most people.
Well, Patrick, you've got the last word. Patrick Halley, what are some of your closing thoughts for today?
I think I want to say that, you asked earlier, right in your intro, about whether the FTC is a sufficient cop on the beat. And the FTC has been a cop on the beat for decades at this point, and they have a long track record of being able to address competition and consumer protection issues. They've been doing this. They've brought hundreds of cases under their current statutory authority, which looks at unfair and deceptive trade practices. In the internet space, in the last 10 years, they've brought 101 actions, enforcement actions, looking at certain types of behavior and activities by lots of different companies in the internet ecosphere. I will say, going back to my earlier point about ISP specific rules and why we have a concern about that, one of those 101 cases was an internet service provider. But it's very clear to me that the Federal Trade Commission is up to the task. They're currently holding a series of important hearings in Washington. They have been over the last several months, and they're continuing to do that. And so I think one of the important things we need to do going forward is to recognize the expertise that agency has, to arm it with sufficient resources as necessary to continue to play that role, and to give it the authority that it needs to be that effective cop on the beat. And I think that they're ready to do that, and that's an important part of this discussion.
Well, we sure did cover the waterfront. I'd like to thank our panel of Patrick Halley, Jennifer Huddleston, and Brett Swanson. And thanks to all of you for watching today as we tackled digital privacy challenges in 2019. Please visit digitalpolicyinstitute.org to see the full biographies of our panelists and to learn more about our institute and the many important digital communications topics we're following. Also, today's webinar and all past DPI webinars are archived on that site. So for the Digital Policy Institute, I'm Barry Umansky. See you next time.